Are counter-terrorism laws and human rights protections fundamentally incompatible?
It seems to me that all counter-terrorism starts with considering the basic human right, which is not to have one's life or safety arbitrarily interfered with. And so no, the human rights discourse is the appropriate one to see all our counter-terrorism laws.
Why is it important that ministers are only able to cancel the passport of a dual citizen after a criminal conviction?
The law that's proposed at the moment does have the possibility of revocation of citizenship, if you have another one to fall back on, by a minister if there's been a relevant conviction. It's important that there be that prerequisite in such a case because the notion of punishing somebody for their conduct without there being a criminal trial in relation to that conduct is contrary to what the Constitution and decent dealing would require.
How do new foreign fighters laws move away from human rights law and towards the laws of war?
The foreign fighters legislation in this country seem to me to be highlighting the problem the whole world has with what I'll call irregular warfare. IS has obviously pretensions to be a state. No country that I know of has the slightest intention at present of extending such recognition to it. However, it fights, it has the so-called young lions, and the question is whether it is truly appropriate for us simply to criminalise that as terrorism. Rather, it may be that the wholesale ignoring of the Geneva Conventions by IS and similar bodies suggests rather that they should be treated as the war criminals that they are, namely the commission of crimes against humanity and the commission of war crimes.
Will new laws imposing possible jail sentences for individuals like journalists who reveal details of special intelligence operations restrict valid public debate on government actions?
Look, I hope not, but much depends upon the safeguard systems that in particular focus on the role of the Inspector General of Intelligence and Security because disclosures to IGIS are not within the criminalising of disclosures of special intelligence operations. It has to be recalled though that these are laws that are very similar to those that already exist with respect to police controlled operations, and the fact is that there are very few people I've heard who wish to justify endangering undercover agents.
So where should the balance lie between freedom and security?
One thing I think that thought and legislative action in this area throws up in Australia and internationally is that the idea that there is a spectrum along which one moves a needle to say I'm going to give up this much freedom in order to get that much security is a completely misleading image. The notion that freedom ought to be given up in order to secure safety is one that I think plays into the hands of the very people who are threatening our safety. And so it seems to me that the task, not a difficult one in principle, but nuanced in practice, is always to ask whether a proposed law will actually hold out any improvement in security while at the same time not giving up a single bit of worthwhile freedoms.